Hi, I'm Carlos Aguila and I'm a Florida lawyer. I help bring peace of mind to families by safeguarding their loved ones. Today, I wanted to share some information regarding guardianship advocacy that can benefit families and caretakers who care for individuals with special needs. I'm surrounded personally and professionally by people who care for individuals with special needs, and I've realized there's little or misguided information and little awareness regarding guardianship advocacy. My wife, who's a speech pathologist, and youngest sister, who's a behavioral analyst who care for these individuals, had little information regarding this topic despite their exposure with the community. My goddaughter herself has autism, and eldest sister had no information regarding this until I informed her. For this reason, I wanted to share some general information regarding guardianship advocacy, including what it is, who it's for, why it's important, and if it's a good fit for your circumstance. Hopefully this video will shed some light, answer some questions, bring some peace of mind, remove unnecessary stress, and ultimately assist you in understanding the process and risk so you can make the best decision for your loved one. So let's get right into it. What is guardianship in Florida? Guardianship is a legal proceeding where a guardian, who is typically a family member, is appointed by the court to supervise a person who does not have the ability to care for his or herself. Parents of children with developmental or intellectual disabilities should begin to explore guardianship as their child approaches the age of 18. The reason why is because under the law, when your child turns 18, you as the mom, dad, or caregiver no longer have the right to make decisions for your child. Under the law, when your child turns 18, they make all of their decisions regardless of their disability. They decide their medical care, their finances, they can enter into contracts, they can be sued, they can get married, they can be charged as an adult for crimes. Parents of children with developmental disabilities want to continue to make those big decisions for their children as they have been doing since they were born. But the question becomes, how can they continue to make those decisions if the law says they can't? Thankfully, Florida recognizes this concern and created a specific law to assist parents or caregivers who want to continue to advocate for their loved ones. It's called the Guardianship Advocate Program, and if you haven't heard of it before, you're not alone. My wife, my eldest sister, and my youngest sister, all of which who care for these individuals, had little to no knowledge regarding guardianship advocacy. So what exactly is the Guardianship Advocate Program? In Florida, there are two options to get guardianship for individuals with developmental or intellectual disabilities. There's plenary guardianship, which is your traditional type of guardianship that is most commonly reserved for elderly people and the mentally ill, and then there's guardianship advocacy. Guardianship advocacy was created to assist parents of children with developmental and intellectual disabilities get guardianship over their child in a quick and cost-effective fashion. Both options end up doing similar things. However, plenary guardianship is expensive, requires a court-appointed panel to determine whether the person is incapacitated, and takes longer than guardianship advocacy. Getting guardianship through the advocate program is quicker, less expensive, and does not require a court-appointed evaluation panel. What's even more beneficial of getting guardianship through the Guardianship Advocacy Program is that the individual with special needs will not necessarily be deemed fully incapacitated and can retain some of their rights. In fact, the court is encouraged to use the least restrictive guardianship so that the individual can retain as many rights as possible. By now you may be asking yourself, this is great. When can I apply to become my child's guardian? If your child is under the age of 18, the law allows you to apply for guardianship 6 months before your child turns 18. If you choose to apply early, the guardianship process can be completed so that the guardianship becomes effective as of your child's 18th birthday. Filing early may sound attractive, but there are some things you should consider before doing so. Ultimately, when you should apply is based on your particular circumstance. Applying early may be beneficial to your situation. However, applying too early or late may result in delays and money or benefits lost. Applying at the right time is crucial, so seeking advice from someone knowledgeable in this area may be beneficial to avoid these delays and out-of-pocket expenses. Great. Now we know what it is, when to do it, but why should we do it at all? When your child is born, you have natural guardianship over your child. This is why you have the right to make all of their decisions, but when your child turns 18, they are considered adults, and regardless of their disability, they receive all of their rights, and your rights to your child are gone. These adult rights come with consequences such as being sued in court, prosecuted as an adult for crimes, denying medical care, and being scammed into contracts. Gaining guardianship over your child with developmental disabilities will be the best way to protect your child from those who seek to scam and hurt them. It ensures that you can continue to advocate on their behalf. The question then becomes, is guardianship right for your child? Only you and your family can answer that question. Parents with a child with developmental disability should consider guardianship if their child does not have the capacity to safely make those decisions. Decisions like where to live, who to marry, consent for medical treatment, and how to manage their money. Obtaining guardianship of your child once they turn 18 will bring peace of mind, as it will allow you to continue to advocate for your child or your loved one just as you've done since the day that they were born. Finally, is it permanent? It's not. If your child becomes able to make those major life decisions, you can ask the court to restore all of your child's rights. If your child or loved one is nearing the age of 18 and has an intellectual or developmental disability, you should look into becoming their guardian if it is in the best interest of your loved one. Guardianship for families can be the most effective and responsible way to protect their child. If you have any questions or need any assistance regarding guardianship advocacy, feel free to contact my office. We are here to help lighten the load.